Mr. Tousaw.
Chief Justice, Justices, thank you for the opportunity to make submissions on behalf of Cannabis Culture and other cannabis dispensaries. Canada is on the verge of making fundamental changes to our approach to cannabis, legalizing production and sale to recreational consumers, and this court's decision may have significant effect on this emergent industry. Cannabis is uniquely positioned right now because it is currently lawful for commercial entities to produce and sell directly via mail order to medical consumers. This regulatory regime operates wholly within the federal criminal law jurisdiction and currently permits over 200,000 Canadians to obtain cannabis direct from producers without regard to the province or territorial location of either the consumer or the producer. The proposed Cannabis Act also sets out an exemption regime and appears to also be an exercise of the criminal law power. It will exempt from the offense provisions in the Act the licensed production of cannabis and its sale through provincial or territorial retail regulations, or in jurisdictions that do not adopt such regulations, direct to consumer in the same way as medical cannabis is now lawfully sold. Most provinces and territories have now signaled their general approach to retail distribution. Most appear to be tracking the way alcohol is regulated. Several will create provincial monopolies over retail sales, and it is clear in some cases, notably Ontario and Quebec, and reasonable to assume in others, that these monopolies will function in the same way or more restrictively than current liquor monopolies. Cannabis dispensaries such as Cannabis Culture operate outside of any regulatory frameworks with some municipal exceptions and serve medical and sometimes recreational consumers. They obtain their products from a wide variety of unlicensed producers and processors and do not discriminate based on province of origin. As a result, cannabis dispensaries carry a much wider array of products than federal licensed producers, service more consumers, and have been described as the Federal Court of Canada as lying at the heart of access to medical cannabis. Cannabis Culture is deeply concerned that proposed provincial monopolies over cannabis will undermine the emergence of the industry and the federal purpose of eliminating the illicit cannabis market. Indeed, as we speak this morning, a cannabis dispensary just down the street is being raided and Canadians arrested by police in an attempt to pave the way for Ontario to implement its proposed monopoly over cannabis sales. The extant industry is vibrant, well-entrenched, and more efficient than the current legal medical industry. Transitioning that industry out of the shadows and into the light is frustrated by provincial monopolies that stifle competition and entrepreneurship. Cannabis Culture supports the decision below and supports an approach or test for Section 121 that examines the effects of regulations, not simply the facial purpose. An inquiry that takes into consideration both the essence and purpose of the legislation as well as the practical effects allows for the most principled analysis. Failing to allow courts to inquire into the effects of legislation simply means that legislators seeking to enact interprovincial trade barriers need only be clever and careful in their drafting and runs contrary to the way this court approaches constitutional interpretation in other areas. Simply and exclusively looking to the purpose of legislation rather than considering the practical effects leads to what Cannabis Culture respectfully suggests is somewhat convoluted reasoning. The idea that a provincial liquor distribution branch that markets, publicizes, and generates significant revenues from the sale of alcohol is doing so to improve public health. Accordingly, Cannabis Culture supports the position of the respondent and the interveners that suggest various iterations of a test or an approach to analyzing legislation that probes the true nature of the enactment rather than simply its facial purpose, and in this regard finds and supports the submissions of the respondent and the intervener, Federal Express, particularly convincing. Cannabis Culture agrees with the intervener, Alberta Small Brewers Association, that retail provincial monopolies, whether existing liquor monopolies or coming cannabis monopolies, will often run afoul of the test being proposed because these monopolies create significant barriers to interprovincial trade by directly or indirectly imposing costs on out-of-province producers or by limiting those out-of-province producers' access to retail distribution within the province. As the intervener, Federal Express, points out, e-commerce transactions are a common feature of consumer life in Canada, and the enactment at issue completely prohibits those transactions, which would be true for cannabis as well in the proposed regulations in most provinces and territories. Cannabis Culture supports Alberta's approach to alcohol, which does not impose a provincial monopoly and allows private retail distribution in combination with fair and equal access to this retail system by alcohol producers irrespective of their geographic location within Canada. Cannabis Culture also submits that provincial monopolies over retail distribution reduce consumer choice. Prohibiting private dispensaries from participating in the illicit industry works contrary to the goal of federal legislation and contrary to a balanced approach to federalism and the free flow of trade across the country. Thank you.
Thank you.